Hey all, welcome back to the Law Read Slowly. I am Sahil Bansal and we are discussing the law by looking at the text of the law closely and then contextualizing it with a structure so that we proceed slowly and steadily in order to actually gather what the law is trying to say instead of rushing through it. So the first law that we have picked up in the series is the Code of Civil Procedure, and we have already had 4 discussions on the Code of Civil Procedure, and in the past 4 sessions we have discussed what is the history behind the Code of Civil Procedure, what is the nature of Code of Civil Procedure. We have discussed the differentiation between the substantive law and the procedural law, and that Code of Civil Procedure, as the name suggests, is a procedural law. We discussed what is the need for having a procedural law, why do we need uniformity in this procedure, and we also discussed a number of different ideals and principles that underpin the Code of Civil Procedure. We looked at ubi jus ibi remedium. We looked at procedure as the handmaid of justice and not its mistress. We also discussed the constitutional underpinnings of the Code of Civil Procedure. We picked up certain constitutional principles and we saw how these principles are actually exhibited and manifested by the provisions of the Code of Civil Procedure. All of this was an attempt to make you realize that Code of Civil Procedure, as many sometimes think, is not a law divorced from the whole other corpus of law. Code of Civil Procedure operates very much in consonance with other laws in order to serve justice. We also understood that Code of Civil Procedure is not going to operate in isolation. There will be some other laws coming in, like the Limitation Act of 1963, the Indian Evidence Act of 1872, and now Bharatiya Sakshi Adhiniyam of 2023, the Court Fees Act, the Stamp Act, the Registration Act, and of course the substantive law, for example, the Contract Act 1872. They will all come into play to serve justice in order to carry a civil suit forward. Then we moved on to discuss what is the structure of a civil suit, how does a civil suit proceed, how does it progress, beginning from cause of action, moving on to plaint, moving on to summons, moving on to your written statement, date of first hearing, settlement of issues, then the trial itself, judgment, decree, or then you have appeal and you have your review, and along with it the decree holder will have the execution. We also discussed a list of topics that we are going to discuss throughout the series. Now, having discussed all of this, I am somebody who has a penchant for note making, and I would also like to do the same for you, because I honestly feel that while you're discussing the law, while you're engaging with the law, you should also have something to go back to, and in this case it will be your notes. So I intend to actually give you notes that you will take down in the session itself, because I at the very outset am not going to give you something like a PDF or like a pre-made thing. Let's do an organic note taking, so that while you're doing the note taking, you not only get that note on the paper in your own writing so that it feels your own, but you also learn a lot of stuff. It also helps you to revise when we do it organically, instead of me handing over like a handout to you and you read that handout and you move on. And in a lot of cases, with all of the things going on in life, especially for a law student or a young professional, we don't really get to reading the handouts. So it's better that we do the note taking in the session itself and we do it impromptu. I'll dictate it to you and you take it down, and as we progress, if we come across some point that needs a little more explanation, we'll explain it more. This will also be a revision of all that we have discussed in past 4 sessions, because we're going to revise them and we'll keep taking them down. And as we take them down, I need you to also understand. And if you have any questions that are popping up in your mind as we're going through these dictations, please put them in the comments and I will address them in the forthcoming sessions. And also, I believe there were certain points that I would like to add to our discussions, which I will do by the way of dictations itself. We'll discuss them and then we'll take down some dictation on it. And also, I remember that I mentioned King Rex in passing while I was discussing the importance of having a procedural law, and how while we were linking the constitutional principles to the manifestations in the Code of Civil Procedure, I went back and I read that article which actually talks about King Rex. I had read this article a little over, actually around 8 years ago. I read this article for the very first time. It's written by Lon L. Fuller, and it's titled as 8 Ways to Fail to Make Law. So, and as I went back and I read the article again, I realized a lot of our discussions today, even around any law for that matter, are really ingrained in this, because Fuller tells you 8 discrepancies that you can make in lawmaking, and how these discrepancies will lead to an effect on the society, which will lead to a complete collapse of the society and the relationship not only between the humans but also between the state and the subjects. So I would, in my dictation, love to bring in, at least give you like a small paragraph, because it's not a very long read. If you want to read it on your own, I'm sure you can find it on Google or something. Please go read this if you would like to explore it further. But I will give you a paragraph from this article, not per se in verbatim, but I'll give you a summary of it, so that I cover all the basic points that I feel are useful to our discussion, because I read it and I feel there are some points that we need to keep in mind. And this note taking will also help you, because some students approached me on different social media platforms, and they said that if I can also help them in drafting, in telling them how would they draft an answer out of what we're discussing for the examination purposes maybe. So this note taking is also because one of those reasons is also why I'm giving you these notes, because this will tell you how you can actually put all the discussion into a narrative format and how you can utilize it for your examination purposes or otherwise as well. And also it will also tell you how do you write about a topic. I'll give you some technical terms, and I'll also try to give you the number of provisions. Wherever we're talking about a term, we're taking down, because in these past 4 sessions, we've gone all over the place, because they were introductory sessions. So we've gone all over in the code, and we've discussed different topics in very brief, and I've introduced to random stuff in the code, so it feels more familiar to you. Now, while I'm giving you this dictation, I'll also try and give you the provision numbers for whenever we are discussing or taking down a note on some particular aspect of the code. So that the more times that you have these provisions mentioned in your notes that you're taking down, the more you learn them. Because at least what I do is, every time I go back to the code, I read case laws, or I read a piece or a piece of work. Every time that I find the mention of a provision in my own notes and stuff, I will go back to the actual legislation and read the complete provision again. Even if I know it in my mind. So even if I know that section 11 talks about res judicata, but still if I encounter section 11 written somewhere while reading CPC itself or my notes, I will go back to the CPC and I will read the whole section 11 again, and slowly I will read it. And the more I do this, and every time I read it, I end up discovering a new angle to the provision, and I promise you this will happen to you as well. That is why when I'm giving these dictations, I will ensure that I mention different section numbers in the dictation, even if I've already told them to you in a previous dictation. So more frequency of the mention of a provision number will ensure, provided that you go and read it, that you actually learn the section numbers and you discover new things in a provision, because the more you read it, the more you will discover. And it's a fact, unless you are a fan of reading, you will not be able to have fun with law. You should be absolutely engaged in reading. You have an opportunity to read something new, you should grab it. You should not let it go. That's the only way that you can better yourselves at law. Because law is nothing but you reading new stuff and adding on to the existing corpus. Law has been around for centuries. It's still novel. Why? Because we have new cases coming out. You read those new cases, you add new dimensions to the provisions. CPC is 1908. Even today we have new dimensions of it coming out. How? Because we're rereading the law again and again. So keep reading. Now, without taking you more into just discussion-based progression today, let's actually get into dictation. So we'll proceed in the manner that we've proceeded since session 1 to session 4. So we'll begin by writing about the nature of Code of Civil Procedure, and then we will go on to write about the way that a suit progresses. Because I feel these are some very important foundational concepts that you should actually have clear notes on. So while we're progressing with the discussions in the forthcoming sessions, you actually have something to go back to. And you can go back, you can read your notes, you can read these dictations, and you feel as if you have refreshed on all the concepts that we have discussed. And even from the point of view of a lot of students who have reached out to me, I feel this will be really, really beneficial to you. So let's begin. I will try to give you some headings and then dictate the points to it. And I'll try to be as clear as possible. If you need any more clarifications, please feel free to use the comment section. If you need me to be slower in my dictation, or if I'm being a little too slow by being a little too considerate, do tell me that also. And if you would like me to elaborate a little more on a topic, do reach out in the comments, and as we progress in the discussions, wherever organically I can, I will plug it in. So let's begin. So why don't you give the heading, Nature of the Code of Civil Procedure, 1908, put a colon is 2 dots, and then you begin writing under it. I'll give you everything so that you don't feel left out, but this dictation does not mean that you give up on taking notes. Let me tell you that I will give a dictation on the core things that we have discussed, but I will be discussing a lot of stuff as you will see in the sessions. So keep taking notes on your own as you're progressing through the sessions, and then I'll also give you dictations which will help you put everything together. So if there's something which is core and very important to our module that's ongoing, it will be there in the dictation, but to add frills to your answers or frills to your discussions with other people from these discussions, those extra points, they'll stay in the discussions. So you need to take down those from your running notes, and then you can combine them with this dictation. First point, under Nature of Code of Civil Procedure 1908, start writing. The Code of Civil Procedure 1908, begin brackets, hereinafter, inverted commas, CPC, close brackets. So even when you're writing your answers for an evaluative setting or in your law school exams, ensure that whenever you're beginning, you mention the full name of the code, and then in the brackets you mention hereinafter CPC and close the brackets. And then after that, you can feel free to use CPC as an acronym instead of mentioning the complete name. But for the first mention, you will always mention the complete name of the legislation and then proceed with it. Start writing. The Code of Civil Procedure 1908, in brackets hereinafter CPC, is the foundational procedural statute governing the civil proceedings and adjudication in India. It was enacted on 21st of March 1908 and brought into effect on